The next case set for argument today is State of Ohio versus Michael Ross. It is case number 18CA011284. Mr. Ross is representing himself pro se, and the State of Ohio is represented by Attorney Murphy. Is that correct?
Correct, Judge.
Very good. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, please let me know how much time you would like to reserve. I'll keep track and try to apprise you of the time as you proceed through your argument. The arguments are recorded and are posted on the court's YouTube channel, so please remain behind the podium and keep your voice up so we have a good recording of that. I don't believe we have children involved in this case, do we? I don't believe so. Yeah.
No.
Okay. Court likes to refer to children and victims by their initials. So if that's the case, please comply with that request. Court has read the briefs and we are ready to proceed if you are. So, Mr. Ross.
Good morning, Your Honors. May it please the court. I am Michael Ross, and I am the appellant acting in pro se for this matter. We're here today on two assignments of error. The first assignment of error is that the trial court erred in sentencing defendant, myself, to a term of 5 years post-release control at a sentencing that was held in March of 2014. The second assignment of error is that the trial court erred in ordering restitution without a hearing to determine the actual loss incurred. I would like to reserve 5 minutes of my time, if I may, for rebuttal.
You may. I'll try to let you know when you have 5 minutes left.
Thank you, Your Honor. The crux of this issue comes down in the first assignment of error on the issue of post-release control. That error occurred back in the sentencing entry of March 21st, 2014. It's uncontroverted that the trial court made the pronouncement of a 3-year term of post-release control at the time of sentencing. However, in the journal entry stated, in fact, that the court, and I quote, has further notified the defendant that post-release control is mandatory in this case for a period of 5 years, as well as the consequences for violating conditions of post-release control imposed by the parole board under revised code 2967.
So you were notified in open court correctly, but the entry, not only the sentencing entry, but every subsequent entry incorrectly stated a 5-year post-release control.
That is correct.
So let me ask you this. You
Yes.
went off to the state penitentiary, correct?
That is correct.
Did the court ever put a subsequent entry on prior to your release correcting the post-release control from 5 years to 3 years?
No, and that's the crux of the issue. And the state relies on State versus Qualls. I also cite State versus Qualls, and Qualls set out very clearly that the court can make the correction via a non-proton entry, so long as that correction is made prior to the running of the term of incarceration or the term of the sentence.
Now, obviously, you've been released from the penitentiary.
Yes.
What is your current term? When they released you, how long are you on post-release?
Well, post-release control is for 3 years, as I understand it. It's for 3 years. However, this issue had been raised even prior to me being released from incarceration. It was raised again at a sentencing hearing that was held in 2015, and that's what we're here on today, is a direct appeal from a sentencing from October 9, 2015, where that issue was also raised. And although the sentence had ran in open court, we filed a motion to vacate that sentence, cited State versus Oldcroft, indicated to the court that we thought that because the term of incarceration and the sentence had run, that the court was then without jurisdiction to correct the term of post-release control, the error or infirmity in the entry, and that was denied. And not until 2017 did the court attempt to make a non-proton entry to correct the term.
After you were released?
After it was released, yes.
Now, Mr. Ross, when does your post-release control term, 3-year term, expire?
It's my understanding that that term would expire November 18, 2018.
I'm curious as to your thoughts as to whether or not that makes this issue moot if the court doesn't rule, if this court doesn't rule until after that date.
Right, and no, I don't believe it's moot, because I believe it's in the interest of justice and fairness that this court certainly indicate to the child courts in Lorain County and everywhere that the rule of law states that if the sentence is run, then the remedy is to vacate the void sentence. That's the state of the law, and I
Thank
believe
you.
that it's important that the court indicate that.
I'll try not to interrupt you with any more questions.
That's fine. So that's, in a nutshell, the issue with post-release control. As it relates to the restitution, the second assignment of error, where the court has ordered an amount of restitution without holding a hearing, the state will argue that this issue is barred by res judicata. 2918 states that as long as there is an objection, or when there is an objection to restitution, that the court shall hold a hearing to determine the amount of an actual loss. At the hearing, the sentencing hearing of 2014, in the trial transcript, there was an objection. However, that issue was not raised on appeal from that 2014 sentencing. This court reversed again, and there was a sentencing in 2015. Again, that issue was raised on the record at the sentencing in 2015, and I would suggest that at the sentencing of 2015 that we're here on appeal from today, that sentence significantly changed. It changed in a couple of ways. One, the term of that sentence went from 9 years to 6 years. So the child court added a $10,000 fine at the sentencing of 2015 that had been vacated in 2014. And the trial court in 2015 issued a sentence on counts 3 and 4, which had been merged and no sentenced in 2014. The 2015 sentence included restitution. It's uncontroverted that a significant amount of restitution had been satisfied by co-defendants, and that the restitution was in fact a joint and several liability. I believe that it is my position that the court should have held a hearing at the 2015 sentencing to determine the actual loss, what was left, and what would, if, to the extent there was a loss, what was left and proper to be added to that sentence. Restitution is an integral part of each and every sentence. It was a part of the 2014 sentence, and it is a part of the 2015 sentence, and we believe that the court failed in ordering a hearing to determine the actual loss, and that the restitution is clearly in there, and that it would be an abuse of discretion for the trial court to order restitution in an amount without taking into account the amount that has been already paid, just as it would be an abuse of discretion for the court to lower the sentence, order a sentence, and not take into account an amount of time that had already been served. So with that, if you have any other questions, I'd be happy to entertain those. Reserve my time for rebuttal.
Okay. Very good. You will have 5 minutes for rebuttal.
Thank you.
Of course, you have 15 minutes, Mr. Murphy.
Thank you, Judge. Good morning. Nice to see you again, Judge Carr, Judge Haskell.
Do you think it makes a difference as to whether or not, I'll start off with a question.
If I could, just for the record, Brian Murphy, I'm Assistant Prosecutor with the Lorain County Prosecutor's Office.
Thank you, and I apologize for jumping
Not a problem.
the gun here, but do you think it makes a difference in a case like this where the court correctly advised Mr. Ross of PRC the use of a non-proton entry, as opposed to if the court incorrectly advised Mr. Ross or did not advise Mr. Ross?
Yes.
You know, what the effect of a non-proton entry, does it make a difference in those scenarios?
Absolutely.
You think it does?
The non-proton could only be used to make the record reflect what the court actually had decided on the record, not what it should have decided. The state would concede that. The non-proton should speak the truth. What I need to point out immediately is that the March 2014 resentencing date That's the date we're going back to, March of 2014. And it's my understanding that as of that time, Mr. Ross remained imprisoned. That he did not get out until late November of 2015, which of course is consistent with the 3-year post-release control supervision period expiring on November 18th next month.
When was the non-proton entry put on?
Judge, it depends on what non-proton you're talking about in this
The one
case.
that would have
Ultimate-
imposed the 3-year PRC.
Right, ultimately, that non-proton entry was written November 20th of 2017 by Judge Robert Brown, who was sitting by his side there. That non-proton actually dates all the way back to the first resentencing, when, after this court heard the direct appeal of Mr. Ross and remanded the case. There was a March 2014 resentencing. I believe it was March, a May 9th or 19th, I believe it's 9th, 2014 journal entry was then done from that first resentencing. But if you look at the transcript from that resentencing, from the direct appeal that Mr. Ross filed, and that he was successful on in part, the court at that time merged 2 counts for engaging in a pattern of corrupt activity, and second one escapes me at this point, for 2 second-degree felonies, conspiracy to engage in corrupt activity. So those were the 2 second-degree felonies. And the trial court on that resentencing, the first resentencing after the direct appeal, said 3 years post-release control, while Mr. Ross was still imprisoned. And that's why Qualls applies in the matter.
But are you saying that the court's entry from that court appearance reflected a 3-year PRC?
No, it did not. It reflected
Isn't that a
5
problem?
years. No, it's not a problem. Because that record, that journal entry should reflect what the court said. And the court clearly said 3 years.
Do we vacate that journal entry?
I don't believe you have to vacate the journal entry. See, what adds to this sort of confusion is that Judge Brown in February of 17 writes a journal entry saying post-release control is 3 years. From my perspective, if I were a judge doing a non-protunct entry relating to a sentencing, definitely with regard to a sentencing, based on criminal rule 32C, I would do I would reproduce that journal entry. And perhaps that's the state of law. I couldn't quite find that. If I were a trial judge, though, I believe the best practice would be reproduce that entire journal entry, because Mr. Ross here is trying to appeal his basically resentencing upon direct appeal, and it keeps saying 5 years, 5 years, 5 years, 5 years. I mean, it's something like 3 or 4 entries. He finally gets one that says 3 years, but that non-protunct is not technically appealable, right? He's got to appeal the sentencing entry. So I think, at least for my mind, the best practice would be to reproduce the entire sentencing journal entry, noting that it's a non-protunct to reflect that I, as the trial judge, said 3 years at sentencing, the original said 5, but I'm doing this order to indicate 3 years.
So counsel,
Yes, Judge.
before the defendant was actually released from prison, as the defendant was released from prison, the parole board actually gave him 3 years PRC.
That's my understanding.
So that, even though there was no entry that said 3 years, the parole board did what the law required.
Correct. Which, of course, is really against what the state of the law is, which is that the parole board as an administrative body is supposed to do what the journal entry says and impose 5 years, even though they can tell it's a second-degree felony, but I guess in this case,
They couldn't do something that's contrary to law, though, could they?
what's more contrary to law, to not obey the journal entry that the trial court entered, or to impose 3 years and like it believes it was supposed to? I don't know. I've seen the journal entries from the state institution telling trial court judges, it appears your journal entry imposed 18 months, but it was a felony 3 and a felony 5 that sentences and.
So this is not one that where, because a lot of times we see, just like you're saying, that the prison officials will notify the state that there's a problem here, or notify the trial court, I should say, that there's a problem with the sentence entry
Right.
because of the PRC.
Right.
And give everybody a chance to correct that, what it should be before the individual's released from prison.
Right. And I don't know that that didn't happen regarding this journal entry, but frankly, the bottom line is the trial court in March of 14, after the direct appeal, said 3 years in the record, 3 years post-release control, while Mr. Ross was still in prison. It was a resentencing. So the non-pro-tunc, from the state's perspective, is perfectly appropriate in this case. If maybe it should have been done in a perfectly formal sentencing entry to comply with 32CA. I think that would have cleaned a lot up here. With regard to the argument regarding restitution, or there was a brief argument regarding advising of the possible consequences of post-release control. The state just asked that you compare the language from Mr. Ross's resentencing journal entry with the language from State versus Grimes, the 2017 Supreme Court case, as I'm sure you're well aware, and the language is virtually identical. With regard to the restitution order, that restitution order dates back not just to 2014. That restitution order dates all the way back to the original sentencing entry. Okay? Because there was a direct appeal. The direct appeal raised no issues regarding restitution. None. And therefore, raised judicata bars the court from even holding a hearing or exercising jurisdiction over restitution at this point. By not raising it, Mr. Ross waived that issue. And that's because restitution, of course, is part of a sentence. It's a sanction that's imposed. It's a financial sanction. And if it's not disputed at that time, then that's the trial court's final order. And really, you look back to this court's second opinion in 2015 regarding Mr. Ross's case, in which the trial court at the first resentencing resentenced Mr. Ross on a number of counts that included money laundering, bribery, in addition to one or two or a few others. And this court said, well, there were no problems with the sentencing of those counts at that first sentencing in 2009. So trial court, you don't get to resentence on those counts. Those sentences stand, just like the restitution portion of the sentence in this case stands. There's a kind of a sort of creative assertion here, I'll give Mr. Ross credit for, of trying to assert that this court has said no final appealable order several times over. Since that 2015 appeal, I believe there's been like 3 dismissals of his actions. But the fact that this court has found no final appealable order to hear subsequent appeals does not mean that there was no final appealable order regarding the restitution. The final appealable order regarding the restitution came when Mr. Ross was sentenced in 2009, and that's the order that no longer can be appealed today. Mr. Ross could have asked the trial court to enter final appealable orders on subsequent issues since then. He didn't do so, it appears, but the fact that there was no final appealable order subsequently doesn't turn this court's view of no final appealable order into some kind of shield Mr. Ross gets to hold up and say, well, if there's no final appealable order, I can just appeal whatever issue I want at this point. That's improperly expanding the limited ongoing jurisdiction of the trial court. The final remark I'll make is that restitution was jointly and severally imposed. Even Mr. Ross admits that. Once it's jointly and severally imposed, I'm aware of no authority saying that the trial court is in a position under the criminal case number to determine how much is left and who owes what. At that point, it becomes, in my mind, a civil action for Mr. Ross to pursue. He's on the hook for all to none of it, and at this point, if he pays 75% of it today, then it's on him to go file some sort of civil matter seeking to be compensated for what he paid over and above being jointly and severally liable, if anything, at this point, Judge.
Well, who would that civil matter be directed to if his payment of that much money would exceed the total amount of the joint and several
I
liability?
believe the parties would be he and his co-defendants.
Hadn't, at that point, the state been overcompensated? Let's assume that do you mean the victim in this matter? He would have to sue the victim for the money back?
No. I mean, the state can't the victim can't be overcompensated because it's paid through the probation department. So the probation department's going to go, well, if he tries to pay an amount over and above what's still due, the probation department's going to go, we can't take this. It's going to exceed the restitution amount.
I understand that to be the process. I think his point may be that, and I also understand the state's argument in this regard, but his point, I think, his argument is that I have a restitution order with X number of dollars owed that occurred after the point in time when a percentage of that had been paid. And I understand all the state's arguments, but I don't think the concept that he then has to go to his co-defendants and file a civil case, because under your scenario, he wouldn't ever pay more than what he's liable, and whatever it says in the judgment sentencing entry makes no matter.
From the state's perspective, Mr. Ross has no right to a hearing on the restitution. The only obligation he has, the only obligation relating to restitution at this point is for he and any co-defendants to pay it off. The court can't have a hearing to say how much he owes. The court had a hearing, said you owe this, Mr. Ross. This is the amount of restitution you owe. The court can't go back now and say,
I
there's a
understand
different restitution.
the state's argument. It was just the argument regarding going against the co-defendants in civil, but you have answered that question.
All right, and with that, your time is up, Mr. Murphy, so thank you for your presentation.
Thank you, Judge.
Mr. Ross, you have 5 minutes of rebuttal time.
Thank you once again, Your Honors. I'll be very brief. As it relates to the PRC matter, I think it's really very, very clear. The PRC could have been corrected before the sentence ran. And in fact, I filed a motion before I was released from incarceration, bringing this issue to the court's attention that there was an error in the entry, and so that once I got out, I didn't have to contend with whether or not I had to deal with it. I lived in the state of Georgia before I was incarcerated. I wanted to go back home to Georgia and get on with my reentry process. I've been exiled, so to speak, in the state of Ohio for 3 years because the court has refused to deal with this issue and issue these entries that did not comply with Rule 32.
Counsel, so the whole point is, you were sentenced, you thought when you were sentenced, you would have 3 years of post-release control.
No, the court spoke through its journal entry to me, and I looked at the journal entry, and I thought that there was a clear discrepancy and that there was an issue as to whether or not I had 3 or 5 or none, but I realized that the law stated that.
I'm sorry, Kramer, go ahead.
No, I realized that the law stated that if it hadn't been corrected before the sentence ran, and in fact, the sentence had actually run in December of 2014 because it was a 5-year sentence associated with count number 1. So my feeling was that I wouldn't have PRC at all because the court did not have jurisdiction to correct the PRC since the sentence had run, and that the remedy would be, and I cited State versus Holcroft for me to file this motion, and that the court would follow the law and vacate the void PRC. I'd get out and go on my merry way.
But I was just talking about at actual time of your sentencing. When you actually were sentenced, the court told you you had 3 years of post-release control. At that point, you didn't know the journal entry was going to be wrong, you didn't know all this law was going to change, you didn't know all this stuff.
That is correct.
Okay, that's all I asked. Thank you.
Yes. So, again, very simply, I believe that the court is without the jurisdiction to correct it, even with the not-pro talk after the sentence had run, and therefore the remedy would be, and it should have been, and seal is to vacate the void PRC, and that's the state of the law. As it relates to the restitution, I think it's disingenuous for the state to allege in one instance that restitution is part of a sentence, but that there's no final bill or order from the most recent sentencing, which was a de novo sentencing that happened in 2015. My argument is that we are here now on a final bill order from a resentencing from 2015, where the sentence went from 9 years to 6 years, and the term of PRC should have been 3, and the conditions or consequences of violating that term should have been explained, because the conditions would have been different for a 9-year sentence versus a 3-year sentence. And certainly the adult parole authority shouldn't have been given the unfettered opportunity or authority to order to change the sentence, to change the term, and to determine what the consequences might be. And so I believe that the court can certainly speak to those issues and give the child court some guidance as it relates to not only PRC issue, but the restitution issue. And to the extent that the state argues that it's simply a civil matter, well, if the court would vacate the restitution out of the sentencing entry and allow the co-defendants to sort of duke it out in civil court, that would be just fine with me, because the record reflects that the co-defendants actually paid 100% of the restitution, so there is no dollars due to the victim. In this case, the victim would be the public, Lorain County. So if all the money has been paid to the county, and the remedy is now for it to be a civil matter, then it would be the co-defendants who would have the right and opportunity to come after me for their share of restitution that they've already paid to the county. I believe in this case the state is trying to have it both ways, and they're using the journal entry to hold a $500,000 restitution over my head that has in fact been paid 100% by co-defendants. And that is completely debilitating and limiting in terms of reentry, et cetera, et cetera, et cetera, after serving 6 years in prison and having to reroute your entire life. So my argument is that to get to the bottom of what's been paid, how much is owed, the court could have and should have, at the very, very least, held a hearing. It had been objected to determine, okay, just how much of this money is left to be owed by this particular defendant, if it's joint and several, and then put that correct amount in a journal entry, and we'd have to live with it as it may be. So I would ask that this court would vacate the restitution, or in the alternative, remand this matter back to the trial court for a hearing to determine exactly what the proper amount of restitution is for this defendant, what amount has already been paid to prevent an unjust enrichment to the county, and overpayment, et cetera, et cetera. So with that, I would thank you again for your time, your honors, and it's been an honor and a privilege to be before you today.
Thank you, Mr. Ross and Mr. Murphy, for your presentations today. The court will take the matter under advisement, issue a decision in due course. The reports will mail each of you a copy of the court's decision on the day it is released, and the opinions are also posted on the Supreme Court of Ohio's website, so you feel free to check there as well. Thank you both again for your presentations.